All right, buckle up. The court is officially in session. This isn't just some run-of-the-mill drug case. We've got cartel whispers, multiple charges, and a defendant who thinks she can talk her way out of anything. Let's see how that plays out.
We will go on the record in the matters 24 CF 55, 24 CF 167, State of Wisconsin versus Vanessa Dora. The state appears through Assistant District Attorney Kevin Schmidt in person. Ms. Dora appears in person with counsel Gabriel Pollack. We're set here today in these cases for two things. One is a sentencing hearing in 24 CF 55. We had a jury trial, a speedy jury trial on July 23rd, 2024.
7 guilty counts. That's not a slap on the wrist, that's a legal landslide. Ever wonder what it feels like to stand there as a judge rattles off your convictions like a grocery list? Yeah, it's not great.
In which Ms. Dora was found guilty on all counts 1 through 7, possession with intent, amphetamine, methamphetamine greater than 10 but less than 50 grams, 1 count of possession of narcotic drugs, 1 count of possession of THC, 1 count of operating while revoked, 1 count of possession of drug paraphernalia, and 2 counts of felony bail jumping. We are also here for an initial appearance in 24 CF 167. Mr. Schmidt, what is happening in that case? Is that proceeding?
Oh, the bail jump, we had an agreement to read that into today.
All right, so you're asking that the court dismiss and read in 24 CF 167 as part of a global resolution. Is that correct, Mr. Pollack?
Yes, Your Honor.
Quick legal breakdown. A read-in means the charge gets dismissed but still factors into sentencing. Basically, it doesn't disappear, it's like a ghost hovering over you in court. Creepy, right?
All right, the court will dismiss and read in 24 CF 167. As to the sentencing in 24 CF 55, the court did not order a pre-sentence investigation report because Ms. Dora had a very slim criminal history. Mr. Schmidt, argument and sentencing recommendation, please.
Sure, Judge. I'm going to start out by briefly going over the criminal history and the adjustment and supervision. As the court indicated, Ms. Dora has 9 prior criminal convictions, all of which were in Sawyer County. None of the convictions were drug-related. It breaks down to 2 disorderly conducts, a felony criminal damage to property, an OWI 2, a misdemeanor bail jump, and 4 convictions for obstruction. The history goes back to 2004, so it goes back quite a few years. And the last conviction was...
Notice the pattern? This isn't some one-time mistake. It's like a playlist of bad choices spanning nearly 2 decades. Question for you guys. Do you think people can really break a cycle like this? Or does history always repeat itself?
2019, when that year she was convicted of obstruction and bail jumping, misdemeanor bail jumping. She has been to prison before on that criminal history, though. The felony crime damage to property was a probation case with a state-imposed prison sentence of 1.5 in, 2 out. She did get revoked on that and went to prison in 2013. So she was on supervision for about 3 years during that period prior to getting revoked. So she has had 1 period of time in which she's been on probation. The outcomes of every other case has been either a fine or time-served jail sentence from credit built up over the course of the case. When this offense occurred, Ms. Dora was on bond for possession of narcotic drugs out of Sawyer County. She was placed on bond there on January 17th of this year. This offense happened on March 1st, so about a month and a half later. Sawyer has this Justice Point pretrial supervision program that she was supposed to be supervised on. I don't know the current specifics of it, but I do know from reading about it on CCAP notes, it has some sort of like drug testing monitoring component to it. I'm sure Attorney Pollack knows way more about it, and he'll give the court information if it needs it. This supervision, this bond did not control.
So let's get this straight. She was already out on bond, and instead of laying low, she doubled down with another violation. That's like setting your kitchen on fire while firefighters are still inside putting it out.
Her behavior, because while out on bond, she had this violation that amounted to this case. Basically, she was found in our county with Roland Peterson in a van coming through our county from the cities to here. The read-in bail jump is almost exactly the same thing. The bail jump is a violation of the no contact provision. Once again, in our county, just passing through Roland Peterson, the same van. This time there was no drugs on Mr. Peterson or on Miss Dora. However, they did have her daughter with them, Tiana Wade, who had drug paraphernalia on her. She has an ongoing case now in our county now for drug paraphernalia, and she was having a medical emergency at the time. So when the defendant was in our jail, she tried to help herself to get out on her own, our jail for this case. She called up an officer and tried to convince him that she's innocent, that generally she complained about her bond being too high. She tried to convince the officer to help her to get out or get consideration. A big part of the state's argument to the jury was about how calculating and self-interested Vanessa Dora was in those interactions. That's why we played the whole video of the interview, to show the self-interest. She ratcheted up her efforts each time she was rebuffed by Deputy Mogen. Officer, I'm innocent, but I'm cooperating, so maybe that'll help.
This is classic bargaining mode, flipping from I'm innocent to okay fine, but I can snitch on someone bigger. It's like watching someone speedrun every excuse in the book. Spoiler, the jury wasn't buying it.
Officer, my bond is unfair. It's disproportionate what I get in the Sawyer County. Can you help? Officer, I can get you a bigger fish in the cities. Can you help? Or Sawyer County. That was the broad strokes of the interview. The court saw it at trial. I'm going to break apart the pertinent facts of this case and what was shown to the jury as it relates specifically to the sentencing today. So Vanessa Dora is from Sawyer County. All of her convictions going back 20 years are Sawyer County. She really has no connection here. The explanation she gave to the police is that she was going to the cities to visit her daughter and then come back. Burnett's just the place in between the places she actually wants to go. Roland Peterson said something corroborating that. I think that was heard on the body cam video, though he implied that Vanessa's daughter was somehow related to the drugs in some manner that was never explained. In her interview with Bailey, Vanessa indicated she had grown up at some point in the cities or lived there for some time, as she talked about knowing locations there from when she was younger or familiarity with it. Anyways, the vehicle was stopped with Vanessa driving. It's Roland's vehicle. Roland is there. He's higher than a kite.
You heard that right, sitting on drugs. Forget hiding them in the trunk or glove box. This was basically the world's worst car seat cushion. How do you even argue you didn't know they were there?
Vanessa is stone cold, rock solid. She's literally sitting on drugs and paraphernalia in the vehicle. There's tinfoil all over the vehicle. In the back of the vehicle, there's that hatch compartment container containing a roll of tinfoil that all the small bits obviously came from with the way it was cut, as well as the large quantity of drugs. In her interview with Bailey Mogen, she acted entirely out of self-preservation. She said, I'm totally innocent of the drugs in the vehicle. She overvouched to the point of incredulity when she said, I would have never gotten in the car if I knew there were drugs. Well, in the same interview saying, I'm actively using drugs, I'm addicted to drugs. She was just saying whatever she thought in that moment in her time with Bailey, from moment to moment during the course of the interview that would benefit her. She then told a story that deeply concerns me. She talked about her connections in the cities. The gist of her story is that she has this drug dealer in Sawyer County named Jay Potak. At some point or multiple points, she's gone with Jay to the cities. He has cartel connections. He helped her get those connections, and he sells in Sawyer County. At some point, she got close enough to the cartel by sitting with those guys, as she phrased it in the interview, that she can go there on her own. She talked about how she could get large quantities of drugs. She told Bailey she's done so in the past. She said she independently made her own connection with an Asian cartel, though they didn't probe that too much. She denied selling drugs, but said she would trade drugs for items, which is concerning because one, that's still delivery of controlled substances. And two, I think it stretches credibility a bit when she's talking about what she's doing.
Cartel connections. That's the kind of phrase that instantly cranks the stakes to Netflix documentary level. Most local drug cases don't have an international crime syndicate cameo.
I have cartel connections and I can get up to, $1,000 worth of drugs and come back to Sawyer, but I never sell it. It stretches credibility. After doing this interview with Deputy Mogen, she sought consideration from the state. State made an offer, didn't give enough consideration, so it went to trial. The jury verdict was the determination of fact. The jury found that the claim of total innocence of the car, I would never get in a car that had drugs in it, despite being a drug user, they found that unpersuasive. They found I didn't know about the drugs and pipe I was sitting on to be unpersuasive. They found the detailed explanation and the cartel connections and giving specific names and locations to be persuasive. They looked at what she lied about and what she didn't and saw a person acting in a manner consistent with the allegations against her and found her guilty. A person acting with cold, deliberate self-preservation. So here's where I am now. Gravity of the offense. One of the first of the three of the McCleary factors. This is a person with cartel connections. That was the evidence at trial. That's what she said to the officer. She made those through her dealer with the Mexican cartel, according to the interview. And then she made her own independent connections with an Asian cartel sitting with those guys. She lives in Sawyer County, and her only reason being here was travel. Presumably, she also traveled through Washburn County because I don't know how else you get that trajectory there in between here and Sawyer County to go buy drugs and then drive them back to Sawyer County, passing through these two counties. She is the link in the chain, or one of them, between
9-inch. I love how the prosecutor put it, not the pipeline, just a spigot. Translation, she's not Pablo Escobar, but she's still pouring poison into the community one drip at a time.
The cartel in Mexico, the Twin Cities, and Sawyer County. She's not the pipeline, she's not the fire hose, but she is a spigot. That's high gravity. It's rare among our drug dealing crimes we see in Burnett County. We find somebody with this close a connection to the cartel. We're aware that's where a lot of the drugs come from because they have the labs in Mexico. They can make the meth. It's easy to get it over the border. It comes through the pipeline in the cities. Police frequently track the trend back to the cities vaguely, but this close is rare. Usually we're several more links in the chain away. In the federal sentencing guidelines, having any connection of the offense to an organization or gang that is known to use violence is an aggravating factor. By helping that organization at all, even if you didn't do violence, enables their style and methods. There are so many people in the United States and Mexico murdered every year by the cartels. The Council for Foreign Relations estimates about 30,000 people get killed in Mexico each year since 2018. 9 of the 10 highest per capita murder rates among cities are in Mexico. Vanessa knows how dangerous these people are that she's dealing with, that she's buying from, that benefit from her as much as she benefits from them. She warned Deputy Mogen in that footage of how dangerous they were. Don't go there on your own. They're heavily armed. I can get in. They trust me. Her source of her contraband is highly aggravating, is what I'm getting at. The driving while revoked, the possession of THC, the possession of fentanyl, in the larger scheme of things, are of such less gravity compared to the possession with intent. If those were all she was convicted of, those offenses, we'd probably be talking conditional jail and probation. The 2 felony bail jumpings are more concerning. With the volume of offenses, there could have been more bail jumps stacked. There could have been, 1 new crime for each count if we really wanted to, and it could have been a flooded complaint with bail jumps. We didn't do that. We did 2 bail jumps. I think these bail jumps are more aggravated than other bail jumps we see because of 1, the gravity of the offense, and 2, the connection between the offense and what she was on bond for. She was on bond in Sawyer County with the possession of narcotic drugs, drug related. And then the violation is a possession with intent to deliver of drugs. So in the same category as drugs, what you're on bond for, about a month and a half after you're placed on that bond, and it's a higher violation than what you're on bond for. I think those things make the felony bail jumps aggravating. Here's the part where I want to transition to talking about protection of the public, which is obviously related to gravity of the offense. My biggest concern with this whole case isn't even Vanessa Dora dealing drugs. That's number 2 for me. Don't get me wrong, that's an extremely big problem. My number 1 concern here is all the people that she is and could be roping into this, expanding the conspiracy, because she wasn't just alone. Let's go back to how Vanessa described getting her connections. She has a drug dealer in Sawyer County. This drug dealer has cartel connections. She somehow builds her relationship with him strong enough that he's taking her to the cities. He's introducing her to people. She's building those connections on her own. She's built up and trusted enough. She's telling police she can go there on her own now. She can do those things on her own. In fact, she says she has. What that means is she could take somebody like Roland Peterson or a relative like her daughter, Tiana Wade, to the cities and expand those relationships to build those connections. My concern with her is she obviously has no interest in Burnett County. She's from Sawyer County. She's just passing through. But what about the next person she brings in? That person she takes to the Twin Cities and this connection, the same as Jay Potak took her. That sort of knowledge and connections to this source of drugs is extremely dangerous to the public.
This is where the danger really lies. It's not just what she did, it's who she could bring in next. Cartel connections spread like a network, and one bad link can corrupt an entire chain.
Creates a real strong possibility of expanding this behavior into other people and to other places. I think that society needs to be protected not just from, the convicted behavior, possession with intent to deliver, drug dealing, but from somebody who has these connections and can do things like introduce people to these cartel connections in the cities. This finally brings us to character of the offender, the third McCleary-Gallion factor. Her criminal history is not good, but it's not bad. It's 9 convictions over 20 years, which is less than we see from a lot of other people. But if you talk to average Joe on the street, they'd still probably say 9 convictions is a lot. So it's somewhere in the middle. More than half of the convictions are for defying courts or police, bail jump or obstruction. The only time she's been on probation, she had a state-imposed prison sentence and got revoked. So she only time been on probation, didn't do it with something heavy over her head. What I'm leading into there is what we know for the sentence for this is 1, probation is not appropriate. 2 primary reasons. 1, it depreciates the seriousness of the offense. Selling drugs floods our community with poison. It has a lot of collateral consequences that causes people to become unproductive, lose their jobs. That creates more crime itself as they do property crimes like theft and burglary and things of that nature. It's a spillover offense. It's a social enemy offense. 2, I'm sure she needs treatment. With her connections and her history of bail jumping and obstruction, she can't be treated safely in the community. The only time she's done probation, she didn't succeed. She had prison over her head for that, and it was insufficient. I don't think she can be trusted because she didn't follow her bond multiple times, both from the criminal conviction, from the read and bail jump, from the bail jump convictions. She lied to Deputy Mogen about her claims of innocence, and it's not realistic to think she'd succeed on probation, and with the gravity of the offense and her connections, it's too risky to even try.
There it is. The hammer drops. No probation, no community treatment, just straight prison time. Do you agree with the prosecutor here? Or do you think addiction should tip the scales toward rehab over punishment?
I think this is clearly a prison case. I think it's rare when we have a possession with intent case that isn't a prison case just off of gravity offense and protection of the public. And this is not one of those exceptional cases. I think there are a number of aggravating factors, the main ones being the cartel connections. And even though she doesn't have prior convictions, the court saw that interview where she talked about having gone to the cities and buy these large quantities of drugs before, bringing in other people. So how long? How long would be an appropriate prison sentence in this case? The most serious conviction is the D felony, possession with intent to deliver methamphetamine. That's between 10 and 50 grams. The actual amount here was about 15 grams if you add like the one big packet with the two smaller ones. The legislature thinks the worst, most aggravated case of possession with intent to deliver and the worst, most awful offender for this offense would be 15 years initial confinement, 10 years extended supervision, because that's the max. All the other offenses, the OAR, the THC, the paraphernalia, the fentanyl, the 2 felony bail jumps, they happen at the same time. They're part of the same course of conduct. I view those more as aggravating the possession with intent as opposed to something to deal with on their own independently with this offense. When I look at the possessions, I don't really see those as particularly aggravating or mitigating with this conviction because they tell us something we already know. She's addicted to drugs. Merely being addicted to drugs is not in and of itself a reason to send someone to prison. They kind of just reflect the drug use. The OAR is somewhat aggravating on the D felony because it sure looks like her lack of ability to drive is why she roped in Roland Peterson and brought in someone else to drive her. And then just for silly reasons, she went and drove anyways, even though it wasn't even her car. The felony bail jumps, I think, are highly aggravating towards it, given how soon this happened to being placed on bond, that month and a half. And the fact that it's related. It's a drug offense she's on bond for, and then it's a worse drug offense she's convicted of. The amount of meth, I'd say, is not aggravating. Because of this amount of meth, it puts you on the low end of that 10 to 50 scale. So we would expect someone who had closer to the 50 to be considered more aggravating than Vanessa Dora, who's closer to the 10. Her lack of previous convictions for dealing is also not aggravating for her, but that kind of has an asterisk because of her talking to Deputy Mogen and talking about going there, buying large quantities, coming back, trading, I don't sell. The self-serving nature of her interview is aggravating. This is a case where the defendant comes to the court on a serious offense without the benefit that a lot of people have, where they could say, hey, I pled guilty. That's acceptance of responsibility. Acceptance of responsibility is an accepted factor for mitigation. She doesn't have that. And in fact, we have the interview with Deputy Mogen where you really see her doing that self-serving behavior, that spin out one lie here, spin out one lie there, mix this, mix in a bit of truth. The self-serving behavior I've referred to a couple times. To one extent, she did cooperate with police a little bit. That's one of the secondary factors that a court can consider for sentencing, in that she talked about these cartel connections. She was trying to help herself out. But I think really the fact with the way that went and her not getting Deputy Mogen to say what she wanted, I'm getting you out to get you to work, not getting the outcome she wanted, I think really explains what her actual animus was, what her actual goal was. The cooperation was again self-serving. It didn't seem it would help. She wasn't interested anymore. One of the things BCSO did when getting the information from Ms. Dora is they called Sawyer County, said who she was and what she was offering. And they said no, because they didn't think they could work with her. I think that makes sense given her convictions for obstruction.
Out of everything, the meth, the bail jumps, the lies, what really seals the deal is that cartel tie. When you're linked, even loosely, to an organization responsible for tens of thousands of murders, judges don't take it lightly.
Single most aggravating factor, the red flag, is the cartel connections I've already talked to a couple times. It's rare to see that in a case. The court knows that. So to that end, I would ask the court to sentence Vanessa Dora in this manner. On the D felony possession with intent to deliver, I would ask the court to sentence Dora to 10 years initial confinement, 5 years extended supervision. That sentence would encompass 60% of the max, using 2/3 of the max confinement time, 10 out of 15, and half the max extended supervision time, 5 out of 10. I think that Decora is statutorily ineligible for CIP because of her age. I would ask the court to make her not eligible to obtain the benefits of ERP until serving at least 6 years of her initial confinement period. Again, I'm picking that like 60% period. I think for conditions of extended supervision, the court should do no drugs, no paraphernalia, absolute sobriety, no contact with any known drug users or drug dealers, no contact with Roland Peterson, no contact with Jay Potak. I think the court should order no contact with Burnett County. She has no connection to here. She has no reason to be here. We're a place she drives through to go get drugs and drive them back to Sawyer and sell them. And I think the court should consider either no contact with Minnesota or no contact with the Twin Cities if Minnesota is too unconstitutionally broad. She has to be cut off from this cartel connection. It's the single most dangerous thing about her. No driving without a valid license, must obtain a valid license. On the narcotic drugs, I'd recommend, basically on all the other non-felony counts, I'm going to recommend concurrent jail time. I was going to say 6 months for the narcotic drugs, 60 days for THC, 30 days for paraphernalia, 30 days for OAR. For the felony bail jumps, concurrent prison sentence, 1 and 2 out. The way I kind of structured my argument for this is I'm really using the D felony as the primary vehicle because it is all one course of conduct, all 7 of these convictions. The D felony is the most serious. The others kind of happened at the same time, and I'm using them more to aggravate what the sentence should be for the D felony along with the other factors. I chose that 60% mark because there are factors that work well for her. It being on the low end of that 10 to 50 grams is a positive factor for her. Her not having prior convictions for either simple possession drugs or for selling drugs are mitigating factors as well. I think the cartel connection factor and the fact that she's here without the benefit of acceptance of responsibility are aggravating. I think the cartel connection in particular is probably one of the most aggravating factors you could have on a possession with intent where someone hasn't died. I can't imagine a more aggravating factor than that. So I think that bumps it up to something where we're more towards like the middle end of that sort of sentencing paradigm for this offense. That's the basis for my argument. Thank you.
Thank you. All right. I'm just going to ask you briefly to go over, just to tell me, you said 10 and 5 for the D, and just briefly go over, since there are so many other crimes, what exactly you were asking. And I know you were essentially saying concurrent, but
yep. On the narcotic drugs, 6 months county jail. On the THC, 60 days county jail. On the paraphernalia, 30 days county jail. On the OAR, 30 days county jail. On the felony bail jumps, 1 and 2 out, both of them.
All right, so essentially just to have a sentence, but you're using them, as you said, as with the aggravating, as an aggravating factor for the D felony, the intent.
That's accurate.
All right, okay, Mr. Pollock.
Thank you, Your Honor. Before I begin, I did submit with the court the dates that the Burnett County Jail provided to me that Ms. Decora was in custody. I think they said March 1st, 2024 until June 5th, 2024. I have 97 days in that first stretch, and then a second arrest on July 16th, 2024, which has kept her in custody for another 70 days up to today. I have 167 days total.
All right, stipulated?
Yes.
167 days jail credit.
Thank you, Your Honor. I also briefly had an opportunity to show this to Mr. Schmidt prior to the hearing. Ms. Decora's aunt, Ms. Kathleen Allen, provided the following statement. I am Vanessa Decora's aunt. Vanessa is a very kind-hearted person. She's always helping everyone. Her mother, my sister, passed away 2 years ago, and she had custody of her great-grandchild since he was a baby. She's passed away from cancer, so I became legal guardian to Logan, who is Vanessa's grandchild. She's been helping me with Logan since I had him. Vanessa is the only person that can help me with him when I work. please, can you take this into consideration during her sentencing? Thank you. I was not able to attend to today's hearing in support of Ms. Dora, not because she didn't want to, but because she drives a school bus, and this is right in the middle of the time when she has to work. So she was not able to attend. I think Mr. Schmidt alluded to the cartel connections a great deal and the concern that he has with that. And I think that's well placed. I mean, he's right. You don't often hear people discussing connections to drug cartels. That said, I still think that this is a situation where probation and conditional jail can adequately protect the public. Essentially, I think, acknowledged problem here is Ms. Dora associating with people who she should not be associating with. As the court stated, she does have some criminal history. I also, like Mr. Schmidt, came up with 9 convictions, and I had the same list of convictions that he did, so I won't beleaguer that point. But they are lower level, the sort of things that have kept her primarily off of supervision, with the exception of the felony criminal damage to property that Mr. Schmidt alluded to. When you look at the DOC offender detail locator